Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. We have returned, Ann and me, or Ann and I. Ann is a law professor. Ann Lipton is a law professor at the University of Colorado who teaches and researches securities and business law. Why are you shaking your head there, Ann? Because I'm not
shaking my head. That is indeed what I do.
Yeah, it is. She holds up the legal end of the podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
What shall we talk about today? Shall we talk about ExxonMobil? How's that sound?
Let's talk about ExxonMobil.
Let's talk about, I mean, we could, there's a lot to uncover there. And in particular, they've been in the news lately because of their choice of domicile. Yeah. And they have requested shareholders approve a move from its current domicile to Texas. And so we will cover that.
Yep, and we'll get a status update on an increasingly long list of proxy contests brewing for 2026.
Yeah,
and also,
there's some interesting ones kind of cooking there. So let's do that. All right, go ahead, Ann.
Yeah, and I'm just once again reminding everyone of the mailbag. You can email us at shareholderprimacy@freefloat.llc.
Great, let's do that. Let's hear from people. It's been a little bit since we got some reader mail or listener mail. So,
yeah, it actually has been.
Let's talk for a little while about ExxonMobil, which continues to stir things up. It's, of course, the company that, years ago was the subject of a notorious proxy contest where engine number one prevailed in putting some environmentalists on its board, much to everybody's, at the time, legitimate surprise. I think that may have motivated. A couple of them
are still there.
Yeah, some of them are still there, but they're a little we think they're co-opted. But
They've been co-opted.
Right. They also sued shareholders, sued its own, just little teeny kind of ESG proponents over precatory proposals and got in the
Which
news
we did a whole podcast about a while back.
Correct. And then most recently, before this or last week's developments, they're the ones who designed and are implementing a novel and arguably maybe a little unfair retail voting program where they want to allow retail shareholders to vote for their stuff but not other stuff.
Yes. So we had a whole podcast about that too.
Right?
Yes.
Yeah, we did talk about that. So before we kind of plunge into the most recent development, I have something I wanted to ask. Would you prefer to talk about ExxonMobil or Tesla today?
Oh, today?
Or I mean, just overall, which is more.
To be honest, I'm getting a little bored with Tesla. Like enough with the Tesla.
I was kind of wondering. So Tesla. So is ExxonMobil kind of becoming our kind of most recent company of the month?
Well, yeah. I mean, it's just they're like one thing after another designed to be hostile to shareholders. I don't know if it's because they're scarred from the engine number one thing or whatever, but I mean, this is number 3 podcast on Exxon designed to doing things to minimize shareholder voice. So they're really taking this on as much as possible.
Yeah.
We have. Because the retail voting program was very much like you can have standing instructions to vote only for Exxon people and nothing else.
Right. So it was kind of interesting because, for a long time we were continually returning to all the trials and tribulations at Tesla.
I'm sure.
And actually they haven't been, I expect Tesla's going to be back on our radar pretty soon once SpaceX and so forth start to do some really fun stuff, but
it's not just that; they still have pending cases in Delaware. So
yeah, absolutely.
God knows what happens there.
For now, all your students and all my friends are going to start asking about ExxonMobil. So let's cover that. So ExxonMobil announced last week that it wants to redomicile to Texas, where it has a lot of operation, as you'd expect for the largest oil and gas company in the U.S. And this I kind of needed to be reminded of. They want to redomicile not from Delaware, but from New Jersey.
Yeah.
Where it was, been domiciled since the days of its founding when it was Standard Oil.
Standard Oil, yeah, right. Exactly. I mean, because this is the thing, like for those like history buffs about this, New Jersey in the late 1800s was the first state to say we are going to make an effort to attract incorporations.
Oh, interesting.
Attract charters.
So that was the first flight to the bottom or whatever.
Oh yeah, exactly. New Jersey was the first one. They called it the trader state because it was the first state.
Oh.
Really, because it was the first state to say we're going to loosen our corporate law, we're going to make it less regulatory, we're going to allow for the creation of holding companies, we're going to let corporations hold shares in other corporations, which a lot of other states prohibited at the time, and we're going to attract out-of-state incorporations that way. So, of course, the Standard Oil Trust went to New Jersey, as did a lot of other companies, and then eventually Delaware kind of like took the crown. It basically literally copied New Jersey's law. It said, New Jersey law, that's our law.
They're like adjacent. They're like, you just have to like go across this river from Camden to wherever, Dover. I don't know where. Right. But.
I don't know. But yeah, so Delaware literally copied New Jersey law. They actually passed a law that said New Jersey precedent, their court precedents are Delaware precedents. And then they kind of took off with it and ran with it, and New Jersey fell behind historically. But Exxon, which is formerly Standard Oil, remained there from 1899, and it's been there ever since. So this proposal to move out of New Jersey to Texas has a certain like historic feel to it, like maybe the last of
like
the
they're kind of updating. Finally, they were a few decades behind, but they're finally there. So when you said New Jersey in the 1890s, was it? Whatever?
Well, it was the late 1800s that they did this, and I think Standard Oil incorporated.
Oh yeah, they were starting to get organized back then. You said it was the trader state. Do you mean trader like trades or trador?
No, I mean trader as in like betrayer.
Oh, betrayer.
Because it's the one that like decided to make its corporate to initiate this race to make its corporate law loose and non-regulatory, so as to pull charters from other states.
Oh wow! So Exxon's just been there ever since and filed its charter and bylaws and so forth under New Jersey. There's some others that I'm
sure there are.
I've not worked, not within my memory, because one of the things I do early on, believe it or not, is go read bylaws of companies I'm looking at. And a lot of Delaware, recently in North Carolina, a couple of Illinois, of course, I've focused on that, but I've not encountered New Jersey law very, very intently. Is there anything other than, based on what you just said, which is New Jersey, Delaware kind of copied New Jersey, or anything distinctive about like the New Jersey corporate legal regulatory environment?
No, at this point, New Jersey looks a lot like Delaware's law, especially pre-SB 21 Delaware. Like, we all know, we've said a zillion times that Delaware made it easier to cleanse deals. New Jersey looks a lot like Delaware, especially before that change. But Texas is what's different. So Texas, as we've said before, recently revamped its corporate code to give a lot more power to managers and to be a lot less friendly to shareholders. And I just have to say, Texas, Exxon, they call this pro-business. Everyone keeps calling these pro-business moves. That's not accurate. They're pro-manager. Yeah. They're pro-manager. Whether they're
pro-insider, pro-company leadership.
Exactly. Right. Whether they're pro-business in the sense of actually making companies more valuable or more profitable, that really depends on a contested view of what rights shareholders should actually have. So there are a lot, but it definitely is more pro-insider. So there are a lot of little differences between the two states, but there's some specific things that are worth pointing out. So first, Texas allows companies to choose, either in their bylaws or charters, they can choose to limit derivative lawsuits to shareholders who collectively hold 3% of the stock. Texas allows companies to choose in their charters or bylaws to limit shareholder proposals to shareholders who own at least $1 million worth of stock or 3% of the stock. And in Exxon's case, 3% is about $20 billion last time I checked.
Never mind. You're never going to get a shareholder proposal there.
Well, actually, proposal, I think they have to have at least $1 million. So
or something. But still, most of these shareholders don't even have that.
Right.
So,
and Exxon claims, by the way, it claims that even in New Jersey, it can adopt the same limit on shareholder proposals, but that's never been tested. If it tried, it would definitely be sued. So there are maybe some differences in inspection rights. Texas, under its new law, flatly bars shareholders from using inspection rights to explore potential litigation. And
So
that's
when you
really
sorry
different.
to stop right there, inspection rights means books and records
Books and
demands.
records. Right.
Got it.
Books
Okay,
and
got
records.
it. All right.
Texas flatly bars shareholders from getting books and records if they're doing it to explore litigation. And that's really different from, like, say, Delaware, where
Delaware, you could. It's a requirement that you have to do it.
They
right?
practically counsel in favor of it. But
Yeah.
Delaware, this has been really critical that shareholders get this internal document, and that helps them draft the complaint. But
Right.
Texas will not allow you to get access if you're using it for litigation. And Texas also just flatly bars access to emails, text, things like that.
Right.
In New Jersey, you just have to have a proper purpose. You can presumably get books and records for litigation. But I think under New Jersey law, I don't think you can get much more than financial records and board meeting minutes. It doesn't look like there.
So that's very similar to what my experience, at least with Delaware.
Well, Delaware you can get a lot more.
Get a little more,
but then SB 21 makes it harder, so it's a little hard
Right.
to tell. But certainly New Jersey, there's no bar to getting internal documents of some kind for litigation. In Texas, it's barred. And then, and this is the big one, Texas, unlike New Jersey, flatly protects officers and directors from any liability except for fraud, intentional misconduct, or knowing violation of law. So that's
So
really
negligence
high
is
bar.
protected.
Well,
yeah, right.
negligence would be protected anyway, but like just conflict transactions. So
Yes, right.
like, so as I read the law, this is the really interesting thing about Texas. As I read the law, it's not just shareholder initiated lawsuits. If the board wanted to sue an officer, they couldn't under Texas law unless they showed fraud, intentional misconduct, or knowing violation of law. New Jersey is more like Delaware. Shareholders can sue over a conflict of interest that isn't cleansed.
Interesting.
But here's the thing. So with Texas, those minimum holding requirements for derivative actions and for shareholder proposals,
Yes.
those are opt-in. Companies don't have to choose
you have
them.
to actually affirmatively put it in your bylaws.
Put it in your bylaws or put it in your charter. And Exxon says in its proxy statement on this move, it says it's decided not to opt into those provisions. It's not going to institute those minimum holding requirements for proposals and derivative lawsuits, but it has made no commitment to that. Both of those things, limits on lawsuits and limits on proposals, they can be adopted unilaterally by the board at any time.
Right. You can just the board can amend the bylaws whenever they want for whatever purpose. Right.
So Exxon is making no promises that it won't at some future date unilaterally decide to institute those limits. So it's saying right now, we have chosen not to institute those limits, asking shareholders to vote in favor of the move, but it's making no promises that once the move happens, it won't change its mind and say, whoops, now we're here. I guess.
and I don't know, even if they were to make that promise like today, I don't know, how would people hold them to that?
They could. So other companies have done this. So a company called ArcBest, which is also like based in Texas, it also just redomesticated to Texas. And when it did, it actually put a commitment in its charter not to adopt the minimum holding requirements for derivative lawsuits.
So they actually put it in the charter, which is subject to shareholder approval.
Exactly. Exxon's not doing anything like that. And there's another example. Fidelity National Financial, it actually wanted to move from Delaware to Nevada. Okay. Now, Nevada, like Texas, says there's no liability except for like fraud, intentional misconduct, that kind of thing. Much higher than Delaware. But Fidelity National Financial, they tried to get a shareholder vote in favor of the move, and shareholders refused to vote because they didn't want to lose those protections. Right. So once again, Fidelity put National Financial, not Fidelity. Fidelity National
this
Financial,
isn't Fidelity Boston. This isn't the Johnsons, right? Okay.
Yeah. Good. So Fidelity National Financial actually put in their charter that they were going to waive the protections of Nevada law so that they the no liability except for fraud, intentional misconduct, whatever. They put in their charter that they would have the same standards as Delaware. Essentially, they could be liable for lack of good faith and for lack of loyalty, conflict transactions. So it put that right in its charter. But Exxon is not waiving anything. It's not waiving those extra protections against any liability except for knowing misconduct, whatever. And it's certainly not promising that it won't later adopt the holding requirements for proposals and derivative lawsuits.
All right. So just to recap for a sec, at least so I can understand that there's, by making this move, and I want to actually talk about it a little bit, because the move, if you kind of set aside some of the ways in which it's really bad for shareholders, it makes a modicum of sense, which we can talk about in a little while. It's going to basically allow Exxon to limit shareholder lawsuits or derivative lawsuits in significant ways, right? If it wants to, and also limit shareholder proposals, which are two things. Well, shareholder proposals, for whatever reason that I still do not completely understand, really annoys Exxon.
It would annoy everybody. I mean, the latest is Chubb. It's being sued.
Right.
Chubb
declined service or something on some.
Yeah, they declined service.
There.
They're being sued by one of their shareholders for not including a proposal on the ballot, and they're claiming they didn't receive proper service.
Yeah, right. So anyway, but for whatever reason, again, that still I don't fully appreciate is these shareholder proposals, which I would think to most, especially a mammoth company like Exxon, would be just kind of a nuisance. But is really something
their revealed preferences. They
don't like it, and I just don't get it. And then also shareholder lawsuits, and then there's cousins to that. For example, so the books and records demands that would support a shareholder lawsuit are being limited, and there's I think you mentioned something about officer and director exculpation, but I think that's right.
Well, they can't be liable. You can't file the lawsuit if they choose to opt in. You won't be able to file the lawsuit unless you hold a derivative lawsuit, unless you're holding $20 billion worth of stock. Right. But also the liability standard would be that that any shareholder would have to show intentional misconduct.
Right. Yes. Yeah, so really high bar for showing wrongdoing.
Yeah. As opposed to what we usually talk about, which is a conflict of interest.
Right. Exactly. All right. So now this is Exxon has expressed it would like to do this. It can't just do it itself, though. So what did it do? It put it on the AGM agenda for this year.
For this year. So shareholders have to vote in favor.
And it's what votes required? Do you remember? I didn't.
It's got a majority of the votes cast, I believe. I haven't double checked it, but I'm pretty sure.
Well, this is.
Votes outstanding.
So this is a majority of all the votes. I don't believe Exxon would have a supermajority.
No. I'm pretty sure. I mean, I don't have it in front of me, but I'm reasonably sure it's
right because they're amending the charter.
It's technically. I think legally it's a merger because there isn't I think they're legally merging into a company.
Into a Texas entity or something
like that.
Yeah, cool.
But so the interesting thing here is that Exxon doesn't have a controlling shareholder. So
a lot of these
moves, right? A lot of these moves we've seen controlling shareholders do it unilaterally. We saw Tesla, which is his own special case. Exxon doesn't have a controlling shareholder, so that means that in order to get the votes, which I'm pretty sure is majority of the votes outstanding, shares outstanding, it's going to have to convince the big normie asset managers like BlackRock and Vanguard.
And State Street,
and State Street. Now they voted because those are the ones who hold big chunk of stock. Now obviously they voted in favor when Tesla proposed moving to Texas, but remember at that time Texas hadn't changed its law yet. At that time, Texas's law was pretty similar to Delaware's. There was even a whole expert report on how similar the laws were.
Right.
So if BlackRock and Vanguard and State Street vote in favor of this now, they're really voting to reduce shareholder rights kind of significantly. Yeah. And Vanguard, I checked. Vanguard's proxy voting policy says it will oppose changes that do not safeguard shareholder rights. State Street says it values shareholder rights. BlackRock, it's a little more non-committal.
A little more wishy-washy, right?
It says it'll evaluate if a reincorporation reduces shareholder rights, but it might still vote in favor if the overall benefits outweigh the costs. So it's really unclear why they would vote in favor, other than we also know that the big asset managers are under a lot of pressure to prove that they support fossil fuels. They've been accused.
Right.
A lot. They've been sued for being too woke by supporting climate change resolutions. Yeah. BlackRock and State Street are right now fighting a lawsuit in Texas. Ken Paxton and a bunch of other red states, Ken Paxton, the AG of Texas, and a bunch of other red states sued BlackRock, Vanguard, and State Street, alleging that their climate change resolutions were essentially a conspiracy to
it's a collusion. Output. It was the antitrust argument.
Right. And Vanguard settled out. As far as I know, BlackRock and State Street are still litigating. So I'm concerned they may feel a lot of political pressure to support this move, regardless of their actual sense of whether it's good for shareholders.
All right, go ahead. Sorry, I have a
you don't think they're going to feel the well? Anyway, I assumed Exxon wouldn't have proposed this unless they already kind of felt out where they were. So I think it's likely to pass, but I think it's going to be interesting to see the messaging around it. And I'm going to have my questions about whether BlackRock, Vanguard, and State Street, if they vote in favor, are doing it because they genuinely think that it's better for shareholders or at least neutral, or because they feel like they can't really oppose Exxon.
You can be sure that they pre-cleared this, or at least discussed it with the major shareholders. Exxon's gotten burned, enough by particularly the engine number one situation where they Exxon's a famously arrogant company in its governance just over the years. That's why engine number one was able to succeed the way they did, but that was 5 years ago now. So that's the first thing is they have at least discussed it with them. Okay.
I mean, the thing is that the interesting thing is there are really proxy solicitation rules that limit what kind of communication they can make. But
and there's also
sure
there's and I would guess that most of the big institutions are a little wary about having too much in the way of conversations about this kind of stuff because of the they don't want to start filing 13Ds if that's going to become necessary. But that's also depends a little bit on the direction of the communication. But anyway. So I think I would think that that at least the big institutions, you can include some others, J.P. Morgan Asset Management and T. Rowe Price, whoever the top 10 or 12 or whatever are, they're probably a little inclined to support this or to not oppose it. That's my guess. I hope I'm wrong, but.
I'm sure we're going to see a lot of, exempt solicitation.
There's going to be a lot of
filings.
communications, a lot of people jumping up and down. A couple things, though. First, Exxon also has this enormous retail base of shareholders.
3% of which, or 2% of which, have actually signed up for their program, by the way.
Right, right. But they, Exxon, they can, they make a case here, which I'll talk about in 2 seconds. Okay. Second, there's a lot of other institutions that just, view this as an arcane or routine or whatever. They're not going to be paying close attention unless they're, really following the proxy advisors, ISS and Glass Lewis, which I almost certainly will oppose this. They opposed it in Tesla.
No, they didn't. No, they didn't.
Didn't they oppose?
No, because remember, at that time, Texas's law.
Oh, right. Okay.
Was very similar. To
it was the comp stuff. Anyway.
Yeah. I don't think I'm pretty sure ISS didn't oppose the move. At Glass Lewis, I would have to check.
Well, anyway, I would expect that the proxy advisors would likely, unless the political pressure is mounting on them so hard.
The political pressure is probably mounting on them hard too. But I'll actually be really interested to see what the proxy advisors say, given how Texas's law has changed since the Tesla move.
Right. So but again, I'm not trying to diminish that this is a dilemma for all these institutions. And part of the problem is that Exxon can kind of make the case that it's really a Texas-based.
It really can, but that has nothing to do with the incorporation. And the thing is that
of course
it's not
not.
and they can't even claim that, oh my God, we are the subject of totally frivolous, distracting lawsuits, because they actually aren't.
No, right.
And they aren't going to make this commitment, though. But they aren't making a commitment to not take advantage of,
they moved.
Or it just.
I remember I was living out in New York when I was my first working in New York, and it was a big deal because Exxon pulled up its corporate headquarters from Rockefeller Center. It was based in New York City for decades and moved to Plano, moved to Texas.
But that makes sense. That's operational. I mean, however much companies say, we're moving because we have a Texas identity. I mean, that's silly. It has nothing to do with the state of incorporation. But
right. I'm just saying that's
especially
the case
given
that they're
their
going to
history.
Make.
I mean, somebody pointed out online that they still list something like the names of some of the original incorporators in their charter. That's how much they trace their history back. And New Jersey is actually a big part of that history because of its role in corporate law.
Right. Now, how one more question. Then we're going to have to talk about something else. How symbolic is this relative to, Texas's position in this race to the bottom?
This race with
relative to. I mean, I don't see New Jersey really caring deeply
No.
about this,
So,
but maybe Delaware does.
yeah, so there's been commentary mostly from Texans to the effect that Exxon, being this blue chip mainstream company, this kind of heralds that Texas is breaking through and is poised to be a real threat to Delaware. And I'm not buying it. I mean, first of all, remember, New Jersey's law is probably more like what Delaware's was prior to SB 21.
Oh, sure.
Delaware's now fixed a lot of things that were upsetting boards. But beyond that, I've said this before, and I'll keep saying it, Texas is really very explicitly creating a kind of politicized corporate governance. It's treating corporate governance as a culture war issue. It's targeting shareholder proposals, which usually have a liberal bent. They've got their anti-ESG proxy advisor law, and they're using the court system for this kind of thing as well, like the coal antitrust lawsuit is one. And we've talked about the American Airlines lawsuit. That was in federal rather than state court, but it's still Texas judge, the Texas legal establishment.
Right, yeah.
And in that case, we had a whole pot on this. A Texas federal judge reached the evidence-free conclusion that American Airlines breached its fiduciary duties by having BlackRock funds in its 401k plan because BlackRock was voting for a couple of climate change measures. Ken Paxton, very conservative Texas Attorney General, he actually has sued immigrant-focused nonprofits in Texas to get their charters dissolved. So I think companies are likely to think, boards are likely to think, that they're opening themselves up to political hassle if they incorporate in Texas. What if the legislature declares any board ESG considerations are a breach of fiduciary duty, which has actually been proposed? It didn't pass, but it was proposed. Right. What if the company suddenly gets shareholder lawsuits accusing them of being too woke, brought in Texas courts before judges that seem very receptive
that seems sympathetic
to
that case?
Yeah, I mean, we had a whole pot also on how Target was the subject of an anti-woke securities fraud lawsuit in Florida, and the court refused to dismiss it. That case is still ongoing. So incorporating in Texas just seems to invite that kind of risk. And so here's one sort of example. As I said, a bunch of red states are suing BlackRock in Texas, claiming it's conspiring to suppress coal output. Well, guess what? There's now a tag-along shareholder derivative lawsuit that's been filed against BlackRock. A shareholder is claiming that by participating in this alleged coal conspiracy, BlackRock violated its fiduciary duties to its own shareholders.
As a public company.
BlackRock is incorporated in Delaware, but the shareholder filing this lawsuit filed in Texas before the same judge who refused to dismiss the coal lawsuit, naturally. Now, that shareholder is going to argue they filed there because the cases are related, but obviously that plaintiff also, I think quite reasonably, thinks that this Texas judge, who already said that the claims against BlackRock have merit, is going to be receptive to these derivative claims, even though they'd likely be dismissed in any other courtroom. So BlackRock is right now moving to transfer this Texas derivative case out of Texas to the Southern District of New York.
Right. Oh,
no, not Delaware, actually. They're SDNY. I don't know why. But I have no idea how that transfer motion will go. But I'll tell you this. If BlackRock were actually incorporated in Texas, forget it. There is no chance that they would have this lawsuit transferred. And that's the kind of thing I think companies are risking by incorporating in Texas. Yeah. In Exxon's case, that's not an issue. They're already headquartered there, so they can be sued there anyway. And also, they already have the political protection of the state. And I think other moves to Texas that we've seen either involve Texas companies or companies that are seeking to declare a kind of political alignment with Texas, like Coinbase. But most companies aren't going to want to adopt that kind of political branding.
I'm skeptical that this is going to portend a big wave.
Yeah, I mean,
just like we follow. I can't remember one of your another law professor. Tracks all the Delaware exits and so forth, Ben Edwards, right, and so forth. And, if you look at there's some notable, almost all controlled companies. Yeah. But this isn't, this is a much more complicated issue. But I think you're correct in bringing up some of the dilemmas that some of the big institutions face here in, we're supposed to, honor and respect and support shareholder rights, including the right to sue and submit proposals. But on the other hand, there's a lot of pressure to, for a blue chip company like Exxon to kind of, support their economic wishes. So I don't envy the stewardship teams.
No,
at these companies to try to figure out what they need to do.
But I don't see a lot of companies even wanting to make the move or putting their shareholders in that position because the main thing Texas is selling over, say, Nevada is the political branding. And most companies, if they really want that kind of, liability-free regime, they would prefer Nevada, where they're not adopting
right. If you're really legitimately interested in trying to protect yourself from lawsuits, go to Nevada. Why not?
Yeah. So.
All right, cool. All right, let's take a quick break and come back and look at some current proxy contests, kind of see what's cooking for this coming, as we say, proxy season here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFloatAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFloatAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFloatAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin, and we're talking now about proxy contests. So what's coming up?
Yes, let's do that. We haven't actually kind of even looked much. We did a recap last year about what 2025 was, but we didn't really take a look at what's to expect here. So we thought that would be kind of interesting to sort of see what's going on. And I think and others know that I have this little kind of odd hobby of tracking ones related to universal proxy, because I'm really interested in how universal proxy affects voting, actual votes. Mm-hmm. So trying to see which ones are coming and how they vote is something I've been doing. And it also just kind of informs, what the hardcore activist environment is kind of like, because proxy contests are kind of the pinnacle of that kind of engagement. So here we are, mid-March, and I have counted before this morning. We're recording this on a Monday. There were 16 pending proxy contests that we were expecting would go to a vote in the next 2-3 months, April, May, June, call it. One kind of dropped off the list today. It got converted into a consent solicitation, which of course is not subject to universal proxy rules. So there's now 15 of these that are pending. There'll probably be a few more kind of announced, I would guess in the next 4 to 6 weeks, as most of the notice periods have kind of wrapped up. But there's not everybody's kind of gone public about the contest that they're conducting. Occasionally a company will make the first disclosure. Sometimes it's the activist who files preliminary proxy materials or files a D or just sends out a news release. So now there's kind of 15 that are on the list. That's a couple, 2-3 more than I recall we had around this time last year. So it's a little bit of an increase, but not enough to be, statistically significant. I don't think the sample sizes. That's one of the things I have to always remind people is the sample sizes on this are really small. Mm-hmm. So trying to develop any kind of, really hardcore conclusions about, whether activists are succeeding or whether companies are doing better is really hard when you're only looking at, well under 20 that go to a vote in a year. But what's interesting to me, at least, was who's on the list. There are a couple for Starboard Value, Jeff Smith's fund in New York, which is, of course, a very successful and aggressive activist fund.
They're Olive Garden.
They were the original Darden, right?
Which every year I show it in my class. I'd love something newer, but I teach it because I would love something more newer. It's getting a little old now, but there's still nothing nearly as entertaining.
There's still some truths there that are just great. So they have 2 pending. One is at CarMax that they just announced, I think last week, where they're looking for 2 out of 10 directors. And then another one is TripAdvisor, which is the old Liberty Media holding, which is now independent.
Did they finally get rid of their control structure?
No, I'm sorry?
Weren't they a controlled company? Did they get rid of that?
So now, that's all been changed around now. So they're more of a kind of usual public company. And Starboard Value has just said they're looking for majority of the board, but they haven't said how many seats they're looking for. And one of both those could conceivably settle. Starboard's one of these really good funds that doesn't go to an actual vote that often. Another contest that has a veteran, experienced activist is at a company called WEX, WEX, which is the activist is Impactive Capital, led by Lauren Taylor Wolfe. Really, really experienced, good activist. They're looking for 4 out of 11 board seats. What was interesting about that is, and we talked about this in the pod like probably a year ago, Impactive last year at this time just came out and said, this is how we want to vote, how we're planning on voting on directors. They basically did a withhold or vote no on some of the directors. And evidently that didn't have the impact that they wanted in terms of turning the business around. So now Impactive came out and nominated or notified the company that they're going to nominate 4 out of 11 directors at what we're guessing will be a May AGM. So that's sort of a follow-on to their earlier campaign. There's a couple other interesting kind of things going on. There's 2 different kind of real estate ones. One's called Whitestone. The other one is First Industrial. Whitestone is an activist that I never heard of called Pillarstone. First Industrial REIT is Jonathan Litt at Land and Buildings, who always has one or two.
They're called Whitestone?
Whitestone, the Whitestone REIT.
I just think that's so fun. I mean, BlackRock, Blackstone.
Whitestone.
I mean,
of course.
There's so
Blackstone,
many.
Right, exactly. Whitestone REIT. It's not a REIT I'm familiar. One area that I just never get into is real estate in terms of activism. So there's 2 REIT ones, which are interesting because these are almost always pursued under Maryland law, which is famously, friendly to
I've actually
companies.
seen a couple of those. Yeah, they put an arbitration provision in their bylaws once. There was one.
Right.
Yeah.
There are 3 where they're arguably like not an activist fund, but like a company is pursuing an activist project. One of them is in the shipping industry. So Genco is the target, and a company called Diana Shipping has been trying to do a deal with them. And so they've nominated 6 out of 7 directors. Another one is really interesting where Beretta, the firearms manufacturer, is trying to elect directors at Sturm Ruger. Ruger? RGR is the ticker.
I always thought it was Ruger, but yeah.
Ruger. So in the firearms industry, in the handgun business, and the
I
third,
assume they're not running on a gun control platform.
No, they're unlikely. There's not a whole lot of social ESG stuff there. It's mostly just how the
you get
business is
shareholder
run.
proposals that way, but
you absolutely. But and the third is, I think, going to be very high profile because there's a lot of ego. Is at Lululemon. Lululemon Athletica, where the former founder.
Oh, right. It's the former founder. I saw that in the Wall Street Journal because they
is running 3 out of 4 directors on a classified
They disagree
board.
with their whole strategies.
Right. So there's 3, again, kind of company based, and this kind of harkens back to the bad old days when people were into hostile takeovers and so forth.
Yeah.
So there's some interesting ones that way, to sort of see where activism is going to affect more of the M&A, or some of the REIT ones are kind of cool. Interestingly, in 6 of these 14 or 15, the activists are seeking at least a majority of, let's say, the available seats. That's not necessarily a majority of the board, but that's a majority of what could be voted on. So in a classified board, of course, you're not going to ever get a majority. But so activists are, showing some ambition. So I think that's an artifact of universal proxy, has allowed activists or dissidents or whatever to be somewhat more aggressive in what they start to look for. What they settle for, what they end up getting, it's a different story. But at least, a significant number of these, the activists have at least started looking for at least a majority, and at least 3 of them, I think it's every available seat. So like at the Whitestone REIT one, there's 6 board directors up. I believe that's the full board. And Pillarstone's looking to elect all 6. At Genco, Diana Shipping is looking for 6 out of 7. So that's there's some ambition being demonstrated here that's really kind of interesting. I'm guessing several of these will probably settle based on who the activist is and based on what's going on. A couple of these aren't, like Joe Stilwell, who is a individual activist who goes after regional and local banks. He never settles this stuff. He'll just probably take these to a vote.
And not the clothing one, I guess, because that's just.
Lululemon. Yeah, Lululemon is
never
almost
heard
certainly going to go to a vote. I'd guess there's too much
Well, that at the
too
very
much
least,
ego
they'll have-
involved there.
Well, I mean, since it's really about the strategy for the clothing line, if nothing else,
Yes.
it's going to generate some materials that I can use in a classroom.
Yeah, exactly. Anyway, so that's kind of what's kind of going on now. Like I said, we'll probably get a few more, but there'll probably be a dozen or more for us to talk about in a couple of months to sort of see how the votes work out, whether other ones get added. There's some others that have been kind of talked about. So, for example, I think it was Elliott was making noise about doing something at Pepsi. I can't remember if that settled, but that would be huge.
I thought I saw that settled,
that
but
would happen.
I'm not sure if that's right. Yeah.
Yeah. So
I definitely saw the headline. Okay.
So that's so just to recap, there's a little more activity than maybe we had seen in the past year or two. And the activists are certainly asking or seeking a lot relative to what they'd done before. How it ends up, whether they'll get one or two. Up till now, there's been so far since September, there were 5 that actually went to a vote. In 2 out of the 5, including one I was involved in, the activists won some or all of what they were looking for, and in 3 they got bupkis, they got 0. So and that's again with a really tiny sample, that's about right. Little batting less than 500 is about right for how activists tend to do when they actually go to a vote these days. So anyway, so that's the update for now on what's happening on Universal Proxy, on Proxy Contest under Universal Proxy.
Yeah.
So, all right.
Okay. Well, great.
Yeah. All right. Let's maybe move on and get on with the rest of our week. How's that sound, Ann?
Okay. Sure.
All right. This is Shareholder Primacy, hosted by Ann Lifton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the professor of law and the Lawrence W. Demuth Chair of Business Law at the University of Colorado Law School. You can find me, Mike, at theactivistinvestor.com. You can find Ann at law.colorado.edu. Our podcast is produced and distributed by our friends at Free Float Media. Thanks for listening. We'll talk again soon.